right, y'all. Welcome to our HTP Education and Advocacy Zoom meeting. We thank you all for being with us today. And today's topic is going to be understanding court motions. And we'll be going over how to read a motion, how to understand a motion, what to expect from a motion. And if we get time, we can potentially go through and Fuquan will help us look through how to edit a motion, what to look for, how to improve it to bring it back to your attorney. So as always, thank you. I'm Jackie. We have Juan joining us live, direct from home.
From home.
Yes. And I'm just going to get started with our intro video.
Name's Jonas Francisco. Been down since 2004. I came in 2004, in August of 2004. And I waited 4 years for trial. I went to trial, then lost on the case. So there was no evidence and everything else. It was in Boston, Massachusetts, of course. And then 2008, I was found guilty of a lesser charge for second-degree murder, and then also intimidation of a witness. And then from there, started to appeal my case. But appealing the case, I had no knowledge really of how to do anything because I was ignorant to the law. I didn't know anything about the law. So I had, I still have the same appellate attorney who's helping right now from CPCS. They didn't have a private attorney. If you don't have a private attorney, of course, you need the knowledge to apply that with the attorney. And B, what Fu taught me as being the co-counsel. So I didn't have the knowledge to do that. So through that, since 2008, we've been appealing this case. Obviously, it's about to be 16 years since we've been appealing this case. Just want to talk about quickly on the public record request, which is the Mass General Law, Chapter 66, subsection 10, gives you the right to request any records you're looking for pertaining to your cases or else. But I just want to talk briefly on the Harriet Tubman project. Thanks to the teaching of God Allah Fuquan, who gave me the knowledge back in June when I was in the Harriet Tubman project. I was going to court on a Rule 30 motion for a new trial. The motion got denied. And then, through the teaching and everything else, paying attention to that, I got to learn about the public record request. I was pushed by Fu himself, and then also one of the teachers in the Harriet Tubman, Lara Yisbert, who told me to file the public record request. So they asked to file 3 public record requests, which was one for the police station, one from the DA's office, and one from the attorney's office. So I did the Brockton police. I'm from Brockton, by the way. I did the Brockton police. And then while I was waiting, I filed an appeal because it was late. So the public record came. They sent me a package. Within that package, I found out some records that they were holding without my consent for 19 plus years. I never knew about the existence of the evidence that they were withholding against my will. Part of that were like police reports. Of course, we had some people accusing the witness that went and testified against me. We also have a letter that was intercepted by the Brockton police station. And all these evidence, they were withholding this evidence against my will in the Brockton police station. So I never knew about it. Immediately when I found out, I filed what you call an amended Rule 30. And then I stopped my appeal on the regular Rule 30 motion and filed an amended Rule 30. Went back to Brockton Superior and then tried to raise the issue as a Brady violation now. The Brady violation, of course, is withholding exculpatory evidence that can help me. All this I learned from the Harriet Tubman project. I never knew anything about it prior to joining the Harriet Tubman project. So all these knowledge came from the Harriet Tubman project. So we filed the Brady violation and raised the Brady violation rather, and then on the amended Rule 30, and also inserted the regular issues we had prior to the amended Rule 30. We put all that together, went back. We also had DNA evidence that they had. I never knew, witnesses and also suspects in the case that they had. I never knew about. If it wasn't for this public record request, I would have never known about it because it was very important. and then also very, very, very material to my case. So and then we did that, went down to the lower court. I guess there was I don't know what happened. And then in the lower court, of course, I could say anything right now. The judge, however, did not agree that there was prejudice in this evidence. That doesn't stop there because I'm still going in SJC right now with this case. The Harriet Tubman gave me the knowledge now to know going to the SJC that I had to put all these eggs in one basket and then go to the SJC and raise all these issues and then overturn the case. But I know through the knowledge I'm getting from the Harriet Tubman, I can't be stopped because I'm a product of the Harriet Tubman, a student of Allah Fuquan. I can never be stopped. The knowledge is going to keep growing and flourishing, of course. And that I'm glad it was through the public record that, I got to learn. And this doesn't stop, as I said before, because that's not the only public record I'm doing right now. As we speak, I just received a public record that I just did for an itemized listing of everything on the case file. Those things I never knew about. These are the things I'm learning right now. Everything that I need that I can request from my general law, chapter 66, subsection 10. And then everything that I need, I could request from the DA, the police station, also my attorney.
So I just want to stop that there. I can share the link with you guys also so that you're able to get a full understanding and kind of listen through exactly the process that Jonas went through. But you guys heard from Jonas Francis. He is one of our participants who is still behind the wall fighting for his innocence as a wrongfully convicted man. And as he said in the opening of his testimony, Yusbert Lara and Fuquan helped facilitate and motivate him to put in a public records request, which then gave him the information he needed to put in a motion, an amended motion, so he can go back in front of the judge. And as you can see in the news clipping, he was able to do that. So today's topic, we are discussing motions, why it's important, and how to read and understand it, and also edit it so you're part of your own freedom rescue with your lawyer. So just always want to shout out Jonas, the brothers behind the wall. Their voices are the most powerful. And Jonas, as you can tell, knows the law pretty well, but he went in with very little literacy. So being able to participate in these classes and extract the information that he's getting from the facilitators was able to help his literacy and his confidence in his fight. So Fu, I'm gonna just give it back to you. And if you could just add on anything, because I know you were there helping him in the moment, that may be relevant to today's topic.
Yeah, so, just listening to Jonas, I've been out 6 weeks, 7 weeks, something like that, but it keeps me cognizant of how real that is. Because I remember when he came and was a participant in HTP. And, when we give out information, it's a lot of information. Not a lot of people expect to come to Harriet Tubman and get it the way we was giving it. But this brother was very sincere, very conscious of his responsibility to fight for himself. He capitalized on every minute. And he's someone that took the Jews. He's always sitting in the cut in the back, but he's listening to everything going on as we do the Harriet Tubman project. And, for him to give us updates in the news, then for us to see him on the news, then come back the next Harriet Tubman, to kind of give him that optimism that he's on the right track. Like it's like nostalgic. Sometimes I look at that life like, damn, did I live that? Right? But I was there. And like I miss those guys. I miss Jonas. I miss, Lara, all the brothers there, like just trying to put the work in to get home, right? And that is like one of the main fuels to keep me committed to this particular part of my fight. Even though my life, there's a lot that I have to balance and handle, like this will always be a part of me because there's so many Jonases on the other side who just need information and who's ready to put the work in once you give it to them. So Jonas has been a good ambassador of Harriet Tubman Project. He brings it up everywhere. We be in the visiting room. He's like, yo, Harriet Tubman Project. So, I love Jonas. I appreciate him. He really didn't do it. And we're going to continue to do whatever we can to kind of amplify his voice. Peace.
Thank you, Fu. And you guys may have heard he mentioned the public records request a lot. And that's definitely something that I think we should cover maybe in our next Zoom meeting is how do you put in for a public records request? If we don't do it in the next one, we'll definitely be doing it in 2026, where those behind the wall, while you're waiting, you can put in public records requests to the police departments to request things such as Jonas did and discovered that they were holding for 19 years. But also us loved ones, we could put in public records requests as well. Just like a reporter puts in public records requests to learn about a case before they report on it. It's a public record, so it's accessible to all of us. So we would love to do a training with Food's help to really break down how to access public records and really be able to tangibly assist our loved ones in their freedom because it takes evidence and it takes material evidence, as Jonas mentioned. So thank you all for joining. Again, today we're covering court motions, and Fu knows all about it. So I'm really going to heavily depend on him to navigate us through this. Please take notes. Please, if your loved one calls in, merge them into the call. As always, we record and upload these trainings on YouTube. So if you miss something, it will be available on YouTube so that you're able to take your time replaying and tracking all of this information. So with no further ado, we're going to go right into it with our first slide. What is a court motion?
Yeah. What is a court motion? So a motion is exactly what it is, motion. In order for there to be movement in your case, you need motion, right? So a motion is the document that makes your case move forward. A judge may see something, a DA may see something, an attorney may see something, but in order for it to move, you need to put in a motion. So think of motion as literally motion. In order for there to be movement in your case, you have to use a motion. And a motion is a formal request to a judge for a ruling or order, which can be written or orally requested, made by either the prosecution or the defense. All motions must generally be in writing, and they typically require supporting affidavit detailing the facts of the case, as well as a memorandum of law. Memorandum of law is just what is the supporting law that you're using to support your need to have this motion heard or addressed, right? But motions are categorized as pre-trial, which is everything before your loved one goes to trial or gets sentenced. Trial itself, post-conviction, those are the events after you've got convicted. And each category has specific procedures and deadlines. And when you think about motions, they can be presented at any time. When you get convicted, there's no opportunity that is not available for you to present a motion to contest something going on in the court. And there's literally hundreds of thousands of possible motions for each area. So the more you learn about motions, the more you can pretty much know exactly how to fight your case a little bit more punctual. But that's just the basic overview of motions. Think of motions as the document that's going to bring movement, literally motion to your case.
Right. And to link it to the video you just heard from Jonas, he put in the public records request to get that material evidence, which was newly discovered evidence for him. And then he created a motion with his attorney to be able to put things into play in the courts. So that's why motions are important because you have to be able to get in front of the judge again. So think about everything linking together. And I have an example of a motion here. This is a pretty popular case, Commonwealth versus Sheldon Mattis. When we think about Mattis, we think about emerging adults.
So all formal motions, thank you, Jackie, has the same typeset. So you see in the upper part it says Suffolk County. That always has the county. It can be Hampton County, it could be Plymouth County. It's always going to say Commonwealth of Massachusetts at the top. But to the left, it says Suffolk County. The county always have to be designated. Then on the right side, you have Superior Court, right? Which may be obvious, but you have District Court, you have Municipal Court, you have Federal Court. So it's important to note the court in the corner. So it's Superior Court, which means there's a likely indictment where they got elevated from district court to superior court. So it's in superior court and it's a criminal action. Remember, you have civil, which deals with property, and criminal, which deals with person. So this is a criminal action, right? And every detail is important. Underneath it is the docket number. We were speaking specifically about docket numbers. If you're trying to find a docket number of your loved one, it's always an emotion, right? And they function off docket numbers. If you speak to a clerk of any county and you want any information in your case, they don't even want to know the name. They just want to know the docket because that name may have other cases attributed to it. But the docket always gives the clerk an opportunity to know exactly what case it is. Then lastly is the SJC docket, the Supreme Judicial Court, the highest court in the state. They have their own formal docket. Those are all the cases that was tried specifically that calendar year or heard in front of the SJC, right? So that's the formal heading of a docket. Right under it, you're always going to have the names, right? So this case specifically, it's Jason Robinson, who I know well, and Sheldon Mattis. Now, Mattis was considered the principal defendant. He's the one that initiated it. Jason Robinson came on after, right? But they was using the facts specifically in Mattis. That's why his name pretty much was branded as the person that this case is attributed to. But you did have Jason Robinson as well, who just seen parole. But after the heading, that this is all a general heading, you go into what the motion is about. Like, what is the context of the motion? And this motion specifically was given an overview of the brain science. This case where now a lot of individuals who are considered emerging adults have the opportunity to go home on parole, where 20 and under age is considered a mitigating factor or something that should have been factored in when they were sentenced. They shouldn't have been sentenced to life because they still have the opportunity, according to science, to be reformed. This is the case that changed all of it. So there's always going to be a heading at the beginning of the motion that gives the court an overview of exactly what is the acts of this particular motion. That's always first. Next is the introduction. Introduction is, how do you get here? Like, why are we here? They did explain a 265. 265 is dealing with murder, right? And they have to break it down all the way from the beginning. Even though the same judge probably was on this case for a long time, you have to always break it down from the beginning. 265, it got his docket number again. It lists the defendants in the case, and they just go back to the history of both defendants to get an overview of what happened in their case. That's always going to spell out the introduction. Who are the defendants? What happened in their respective cases, and what are they asking the court to intervene on? Jackie?
Yes, so this is important, the introduction, because this is where you can relate your loved one's case to the motion that you're reading to see if there's any relevancy. Because the purpose of studying other people's motions that were successful in getting decisions made is to be able to see how does this relate to our fight. So you want to find cases similar to your loved one's case and be able to go backwards and study their motions because that's what you need to duplicate. Successful case law. So again, this is a great example of it because it does affect many of our loved ones that we're on the call with today. And then, Fu, if you could just go through some of the procedural history, what these other headings mean.
Procedural history. Remember, it's first introduction. Now it's procedural history. What has been exhausted? Why are you in front of me? Did you present this issue before? When you went to court before, why wasn't this issue brought up? So you have to go through a procedural history. What were your other opportunities of appeal? What was the outcome of those appeals? And that's generally what's happened with a procedural history. The court wants to know, was you ever before us? If so, what happened? And why wasn't this issue brought up before when you was in front of us when you had the opportunity? So there's always going to be an introduction. The judge wants to know what the procedural history is to figure out why are you before me again? Like, kind of spell it out for me. Like, why are we here? And that's always at the basis of it. This case, they broke down each defendant by themselves, but it's usually just one defendant being spoke of when it deals with procedural history.
And Fu, what are these in the bottom here?
Those are footnotes. So when you look at cases, they got numbers on them because it'll mess up the flow of the format of the motion. But if there's a certain fact, like let's go to five right quick, right? If everyone can see it. So it says Mattis was tried as Watt's joint venturer, but they had to give some explanation of what that means, right? And they couldn't do it within that motion because they're still explaining the procedural history. But there's a footnote that gives them a little bit more clarity on what they was talking about, and that's item 5 on the bottom. They just want to make sure that they explain it a little bit more in depth prior to maintaining the integrity of what that part of the motion is meant to represent is procedural history. That's just the fact that the attorneys felt they needed to explain a little bit more on a footnote on the bottom before they continue.
Thank you, Fu. Any questions so far? I know, sorry, we're moving a little quickly, but any questions on anything that we covered so far?
These SJC motions, like usually when you read some, or I don't know if they're motions, but SJC decisions,
Yep.
they always, when they say like, oh, statement of facts of the case, they always go by like the Commonwealth's version. And
Yep.
then some people say like, well, that didn't happen, blah, blah, blah. Like, so how, is there anything that can be done about that? Or like, well, why do they take, I mean, I guess because it's a conviction, they might, but they take the Commonwealth side, but like, I don't know. What do you make of that? Because some people are like, if you just read the SJC decision summary of facts, it can make an innocent person look really, really guilty.
Yeah, so great question. The reason why they do that is the Commonwealth, as well as the defendant, presented alternative theories to a jury because in a criminal trial, the ultimate fact finder is the jury, not the judge, not the prosecutor, not the defense counsel. The ultimate fact finders are the jury. So whenever the prosecutor present their case and the defense presents their case, if we was found not guilty at trial, then that means that our theory was credible. But if we get found guilty, that means the Commonwealth's theory stands. So moving forward post conviction, the SJC affirms the Commonwealth's theory because the jury did. So that becomes the ultimate statement of facts. Once you get convicted, that the SJC leans on because the jury accepted that theory, not because it's ultimately fact, but it's considered fact because that is the jury. No, that is the decision that the jury concluded was right or the correct one. And the SJC do not tamper with the statement of facts because legally the jury are the ultimate fact finders. That's why it's always like that unless you reverse the case.
Great question.
Thank you.
Yep.
Position of the parties.
So let me give just an overview of this motion. So this motion is the SJC's position on previous motions that was submitted, right? So this is formatted a little different, and at the end we will give you a great template for it. But this is just the SJC giving an overview of the position of the Commonwealth and the position of the defendant regarding this specific motion.
Okay. And then findings of fact.
So when an SJC or even a trial judge makes a decision, it's their responsibility to detail the factual record that validated their opinion at the end of the case. So this is their assessment, the court's assessment of the facts that the record indicate is accurate or truthful. Again, this isn't dealing with the Commonwealth's theory at trial. This is specifically dealing with the findings of facts that was introduced in the motions prior to this decision that they're kind of spelling out as the reason why they made a finding in this case.
Thank you, thank you. So there's a lot more to this. We can take our time breaking it down, but as Fu said, we have another document that we're going to share with you all that will really be able to help you break down exactly how to write a motion. And that's something that you want to keep for yourself and also mail in to your loved one. Thank you, Fu. So now that we know what a motion is, types of motions, if you want to briefly go through that, Fu.
Yeah, so there's different type of motions, as I said, pre-trial, filed before trial begins to resolve issues such as suppression of evidence, which means They want to cancel the admission of certain evidence based on it being possessed unconstitutionally. So if you was like, yo, they did me dirty, they went in the house, kicked the door in without showing me a warrant, and they grabbed the gun, that's when, okay, I hear you, but you got to put in a suppression of evidence. That's an actual motion. Dismissal of charges, just, you may say that is insufficient evidence to warrant a stable indictment, so you may ask the charges to be dismissed. Or you can challenge the legality of the proceeding. You can say, well, my attorney wasn't appointed to me, so I had a Sixth Amendment violation, which is access to counsel abridged. But anything regarding the proceedings, because a lot of people forget, it's not about whether someone did it or not, it's whether they tried you legally. That's an argument too. Factual innocence. They have to try you legally. And when you're dealing with pretrial, this is the time that they likely to make mistakes. And if you see something viable, you can challenge the legality of the proceedings. The next is motions at trial. There's so many motions that go on because an attorney can't just say, Your Honor, I object. Like, they have to formally state it and put it in writing if you're striving to advance an issue for your client. So you can request something orally, but it must be followed up with a general written motion that kind of magnifies exactly what you're saying, right? So, but there's motions gone and presented during trial. Then when you get convicted, you have to appeal that decision. And that's where post-conviction motions come in, right? So when you first start studying law, the first thing you want to study is pretrial motions. Which one were denied? Because if they were denied by the trial judge, that means those become your first areas of appeal when you're found guilty, right? So you want to be conscious of your motions that got denied pretrial. You want to be conscious of the motions that was denied during trial because those become the basis of your appeal when you get convicted, right? And those appeals of those motions are created in post-conviction motions, which is filed after a conviction to try to get released, whether an illegal sentence or whether your constitutional rights was compromised. But those are the three areas of motions on a state level that you're likely to encounter once you get arrested: pre-trial, trial, and post-conviction.
Wonderful. Any questions about any of that? I think most of us, our loved ones are post-conviction, but as Fu said, pre-trial is still extremely relevant.
Jackie, it's Lara speaking.
Welcome, Lara.
How you guys doing? Hi, everyone.
Focus.
All right, peace, brother.
I just want to add to everybody, right, that on the Master Rule Criminal Procedure, Rule 13 is the one who deal with pretrial motions, right? And also on the Master Rule Criminal Procedure, Rule 30 is the one for post-conviction relief. So people can check it specifically when it's for pretrial and post-conviction too. Just want to add to that. Thank you.
Thank you, Lara. So that reminds me, I know Fu did a breakdown on the different types of motions, the Rule 30 and Rule 30B previously. And this is a good example of if your loved one is looking to be released for medical reasons while they determine their innocence, or motion for a new trial, like Fu was released on, you need to put in a motion, which is the request. So that would be a post-conviction motion. Thank you, Lara.
You're welcome.
I think I could do this one. Key procedural rules. So you can always make an oral argument in court, but it has to be followed up with a written motion, and that has to be filed with the courts. So although criminal motions must be in writing and filed with the court before a hearing can be scheduled, unless what the court orders otherwise, affidavits and memorandums are grounded on facts and must be supported by an affidavit from someone with personal knowledge of these facts. Motions to suppress or dismiss typically must include a memorandum of law. So memorandum of law is referring back to the law that is supporting what you're asking within that motion. So everything has to be supported by what you know. So not a motion, but facts that are relevant to the law. And then you have to be specific. You have to be very specific. You can't assume that they know something or that they're going to take something into consideration. You have to be specific about all of the points that you want to make clear. and state the grounds for the request in relation to that. So again, always support what you're asking for with evidence and be specific about that. Okay, and then service. The moving party must serve copies of the motion and all supporting papers on all other parties before filing with the court. So that means that the defense attorney has to get a copy of the motion. The prosecutor has to get a copy of the motion. So let's say your defense attorney wants to put in a motion, they have to share it with the prosecution first before it could be filed into the court. So all parties have to be aware of the motion. Any questions on key procedural rules of motions?
Hi, quick question. So when you're sharing the motion with the prosecutor or the opposing counsel, are they able to say anything like before you submit it? Like what is just sharing for them to have that information, or is there anything that they can do to like make it difficult for you to like file it or something moving forward?
So anytime you submit a motion, the other side has the opportunity to present opposition. So they may say in front of the judge, I'm gonna oppose it. The next day they formally submit it. But the judge never makes a decision on a motion without conferring to the opposing party. So you may submit a motion, but it may take the opposing side a year to submit a response. So, for example, I submitted a Rule 30 motion for my new trial in May of 2024. And more than a year later, probably 18, 20 months later, the Commonwealth never put in a formal response to it. They just dismissed it, right? But they assented to it, meaning they agree with my Rule 30 before the charges were dismissed. So for 20 months, they didn't respond to that motion. So a judge wasn't able to make a position on the motion until the opposing party formally responded. So everyone can submit a motion, but it's not going to be ruled on until the opposing party puts it in writing.
That's a great question, Des.
Thank you.
Thank you. So assuming that it's in the reverse, the prosecutor wants to put in a motion, the defense has the same opportunity to review it and create their rebuttal motion to count.
Yep. Or assent to it.
Or agree, right? Assent meaning agree.
Yep. Because motions, some people think, well, the prosecutor's obviously going to disagree. So for my case, for example, in 2021, when they gave me 10,000 pages of evidence, we submitted probably over 100 motions. The Commonwealth agreed with 98% of them. So it's not always that they just shoot it up. Most cases they do. But if it's a strong issue, they're gonna likely assent to it or agree to it.
And some of those motions that I seen in dockets are just motions requesting documentation from like DCF.
Which is huge.
Right. So if they assent to it, then the judge then makes the ruling. So even if both sides are agreeing to something, the judge still has to make a ruling on the motion. So
independent.
Right. So you can't assume that things will go in that. I mean, of course, it's very, very likely, it's highly favorable that you'll get what you asked for if the other opposing party is agreeing with you. But the judge is there as a mediator to make a final decision. So when you think about like any conflict, you have two sides and you have a mediator. And the mediator, ultimately the judge, makes the final decision.
Yeah, to add on your point before we continue, and Andy Dukin, this is when the chemist contaminated the evidence that impacted 35,000 cases. So during that time, Rachel Rollins was the DA of Suffolk. She was saying, if anyone presents the case to me, I'm gonna dismiss their case. So a lot of guys was presenting their case to the jury, saying the judge saying they wanted to dismiss. They had the prosecutors backing, they had the strong evidence, but the judge still denied a lot of people's dismissal. So although the facts were there, the DA assented to it, the judge still independently went against it and made their own ruling as a neutral party.
And if a judge makes a ruling that you disagree with, the next step would be
is to appeal to a higher court.
So if it's a state court, you're now appealing to the federal courts.
To the federal court. All state decisions are overseen by the federal court, but your federal constitution had to been violated if you go to federal court. They don't look at state constitution. They don't look at state rules. They evaluate whether your case was compromised on a federal level with a federal constitution. So they only guide is federal constitution, not state, which there's a difference.
All right. So what happens at a motion hearing? You submit a motion, the opposing party replies to that motion, a hearing is scheduled, you see it on the docket. What happens? Well, scheduling, of course. The court will decide whether to rule on the motion based on the written filings or schedule. And of course, last week we talked about dockets, so you know now how to access your docket and look at the schedule. And with hearings, as you guys know for sure, things change last minute. So you want to make sure that you're checking that docket up until the day of court or the night before court to make sure that it's still the same courtroom, it's still the same judge. And if you want Zoom information, call in to the courtroom, ask to speak to the clerk's office, give them the docket number and ask them for the Zoom. And right about now, I think there's like 98% of courts, definitely Suffolk Court, has Zoom access. So sometimes the attorney will say there's no Zoom ID, they just didn't ask for it. So you want to make sure that you have court support when it comes to scheduling. Argument. If a hearing is scheduled, both sides have the opportunity to argue their positions orally before the judge. Sometimes they will ask for the defendant to be brought in. Sometimes they'll do it virtually where the defendant is able to be present through Zoom. And sometimes they may do it without defendant being present at all. So this is why you have to be aware of the docket and make sure that your loved one is aware that there is a scheduled hearing because they may not even know and they may be speaking about their life and their livelihood without their knowledge. And Fu, what is it called? Is it habeas corpus when they request that you come in physically?
It's just a hey,
A habe.
yeah.
So on the
So
docket,
you have to petition the court to submit a Hague, so you just have access to a important hearing because you have to be present.
and then the decision will be made. Sometimes they'll make the decision in court. Sometimes they'll take it under advisement. Most times they're going to take it under advisement so that they can go over all the paperwork, review everything that was discussed in court, and make a decision later. And I know it can be very, very emotional. I mean, we all experienced it. I was there where you expect a decision the day of and it doesn't happen. So just don't expect a decision right away. If it happens, that's great, but usually they take it under advisement and make a decision later. And there's many different reasons for that, but just don't set the expectation for anyone that is coming for court support that they will get a decision same day.
It can be frustrating. That's one of the most frustrating parts of this. I remember December 9th of last year, we had the courtroom full. The DA was pretty much saying I wasn't a security risk. Everyone thought we was good. But then the judge was like, come back in 2 weeks. So I was upset. Jackie came that day to a visit in the rain, frustrated, right? For the right reasons. Even when I went to court last time, the judge was kind of leaning in, well, I may have need more time. So I'm like, is he about to bring me back? And he was in a position where he could have. But at the end of the hearing, he tipped the scales in my favor and I was actually released. But there was a part of me thinking, he may bring me back to prison until he figure this out. And as a defendant, you hate going through that because you can't lean in being optimistic about your freedom because they got a wide discretion to say, well, come see me in a month, come see me in 2 weeks, or let me consider it. And all that momentum you built, it breeds into frustration for your loved ones because it just feels like an injustice. So it's a very difficult process for all sides.
Joanna, I see you got your hand raised first.
Hey everybody.
How
So
you
I have
doing? Peace.
good. I have Amos here and Luke Nelly, and Luke Nelly had a question that's Jonathan's sister about if you win the federal level, how does that affect the state level, right, Luke Nelly?
Right.
Okay.
Yeah, so if the feds determined that your federal rights was violated on a state level, they get the state to reconsider that decision or remand it back to trial. But the Fed's decision overrides the state. So if the Feds made a position that compromised the decision of the state, that federal decision trumps any state decision. It rarely happens now. A lot of people used to reverse cases in the Feds. Pedro knows this. He's been around a long time. Brothers used to get a lot of, a little bit of play in the Feds, right? They used to look forward to going to the Feds. Now, the Feds aren't reversing as many criminal cases as they did before. And they put a lot of constraints on the federal court's ability to combat criminal convictions in a state court because like Republicans, they feel the states should have complete autonomy on how they run the state. And they feel like the feds shouldn't intervene in state matters. So with that in mind, they created policies that prevent the feds from really upending wrongful convictions because they feel if a state made that decision, that decision should be held more in the state. And the Fed should have no business intervening on a state matter. And that mindset created policies that now make it difficult for defendants to get recourses in the Feds.
Thank you, Fu.
She said thank you.
Yep, peace.
And Pedro, I see you got your hands raised.
Peace. I want to thank everybody here tonight. I'm very grateful to be here and happy, and I'm glad to be amongst you guys that are in the struggle. This is a fight that you need to have a team. I've been fighting for many years, and it's not easy, and you can't lose the faith. But when you don't have a team, then you have more that could bring awareness to you. It keeps you focused, and it gives you more drive. I wanted to say that some of these arguments that you put together, you really need to make sure that your arguments are not just constitutional grounded, right? But also because what it is a bastard language, right? And they got these law books, the dictionary. If you look at the Black Laws Dictionary and you look at a regular dictionary, you're not going to get the same interpretations. It's going to be like it's going to be like foreign language to you. So if you're working on these things, I wanted you all to know that you should start off by getting yourself Black Laws Dictionary. It's very important. It will be very helpful to you in having a lot of understanding. Thank you.
Thank you, Pedro. And most of you should know who Pedro is, one of our HTP alumni, freed but still fighting. So he is absolutely right. You need a team. It's not easy to do it alone. And post-conviction relief, that's where most of us are at now with our loved ones in post-conviction. Fu, can you break this down?
Yeah, so post-conviction, the main one that people see is a Rule 30. And like Lara mentioned, there's rules of criminal procedure. So there's Rule 1, Rule 13 is motions, Rule 14 is discovery, Rule 30 is post-conviction in a state court. So there's two routes with a Rule 30. One of the routes is a motion for a new trial, meaning newly available evidence, newly discovered evidence, which is the same thing. But then there is saying your sentence was illegal. So we said a lot about the Mattis defendants, but in Mattis, it was deemed that the guy that was convicted of life from 20 and under was given illegal sentences because of the science, but that was a Rule 30A. So it's always important to see first, was you tried illegally or was your sentence illegal? If so, that's a Rule 30A. But if there's newly discovered evidence that points to either you didn't do it or your sentence should be reduced based on new evidence, that's when you use Rule 30B. But that is the main motion that defendants use to get some recourse if they're trying to get a new trial or they're trying to amend their sentence. So that at the core is at the basis of post-conviction remedies. Because once you get convicted, most lawyers want to skip Rule 30 or a new trial with the same judge they was tried under and go straight to the highest court. And that can prevent you from presenting viable discovery to the highest court with the intentions of expanding your record. So you always want to explore Rule 30, Motion for a new trial first so that you can expand the record prior to going to the highest court.
Any questions about post-conviction relief or anything else that we may have discussed so far? I know it's a lot, it's new. How does it make you feel? I guess that's my question for y'all. Like, it's a lot of information, it's heavy, it's new language. How are you feeling as you're hearing this or trying to take all of this in? And how do you think your loved one feels when they're fighting for their life, trying to understand all this information?
Hi guys, I don't know if you guys can hear me.
You're
I'm
clear.
Latanya Seymour. I'm advocating for my brother Jeffrey Mitri. Hi, Baquan.
Peace.
Thank you. Peace. Jacqueline, hey. I'm sorry, my voice was gone kind of messed up, so I don't want to do too much, but I just want to thank you guys for the information that you're giving because I'm starting to kind of get back into the fight. He's needing my assistance, and I told him I'd be there. I'm going to piggyback off what Pedro was saying. It can be very overwhelming, very disappointing, very disheartening when you think that you're getting, you know what I'm saying, you're getting somewhere and then to feel that, wow, all that hard work, or even I've gotten as far as I've gotten and things just aren't working the way that we hope. I mean, we know not things aren't going to work overnight because I'm in awe of your case, Laquan, and how far and how you kept fighting, and Jacqueline as well, as I always told her. But it's good to know that it's not just me, feeling like crazy and overwhelmed and feeling like, can I really do this? Can I be that person for him? And he keeps saying, sis, you've done it because you've been a voice for me, when I didn't have one. So, but if it's just very disheartening sometimes to keep the momentum going. How do you do it? How do you keep the fight going? That's my biggest question.
Well,
Me
it's
too.
not easy. That's for sure. I don't ever want anyone to think that this work is easy or it happens overnight. So I appreciate you for acknowledging that, Latanya. And I know that we show up and it may look like everything is good on the surface, but it's not easy. And we're dealing with life while we're trying to fight for our freedom, our loved ones' freedom, our mental freedom. There's so many other obstacles. So for one is acknowledging that we're human, acknowledging that we do need help. It's okay to ask for help. And we're not alone. Like Pedro said, they're depending on us to fail. They want us to give up. So we have to keep going, knowing that they're not taking a day off, and knowing that our loved one deserves their freedom. Our nieces, our nephews, their children deserve, their brothers, their sisters, their parents deserve for them to come home. We just had Thanksgiving, which is a family holiday, whether you celebrate it for, the foundation of it or not, it's about family. So those type of things are going to keep us going because our loved one is not at that dinner table with us. So just thinking about your why, thinking about why this is bigger than you. On days that we want to give up, we may just need a break. We may need an extended break. It's okay to say, I need a break, but to be real with yourself, be real with your loved ones so that they know how to support you as well. I think that's really important. We don't want to front and pretend like everything is okay all the time because that's not real and that's not right for either one of us. You're not being real with yourself. You're not giving yourself a break mentally or physically, and you're not giving your loved one the opportunity to give you a break or to support you in doing that. So just keeping it real. We're all learning a day at a time, but showing up when we can to know that we're not alone. So the Zoom meeting is a perfect example of that. We're going to be here to support and be in community with one another.
Thanks, Jacqueline. Thanks for calling.
Yeah, another point. I think for me, I fought away when I was on the other side, but now I'm on this side. I've always appreciated the advocacy of those who put their life on the line to advocate for me. But it's a little bit more emotional for me to see it on this side, to be at events and I see like the loved ones by themselves. Then when the event's over, they go in their vehicle and there's really no like support, right? And it's one thing to acknowledge a problem, but and it may be premature to say it because we was gonna outline this a few weeks, but what we're working on is we're gonna partner with different organizations to create spaces for those who are fighting for their loved ones behind the wall. Whether we have therapists come in, whether we do day spas, we want to be the space to provide the support because Harriet needed a hug. Like, who's the people that gave Harriet Tubman the hug? Like, that's not in history, but I guarantee there was someone that gave her a hug. So we're not here to be grievance centered what other people aren't doing. When we see a problem, we're going to organize around it. So me and Jackie are partnering with a few different organizations, and we're going to have a day where loved ones can come and just let all this stuff out, right? And we come together as a community. I'm gonna be there. Jackie's likely gonna be there. Y'all are gonna be there to provide support. Once the advocates' morale get low, the likelihood that someone's gonna get released gets low because their main voice is starting to get brittle because of all the pressures that come with cases. So I hear you, sis. It's something I've been seeing a lot more actively from a different lens, and it's something that we're actively organizing around. And anything I say on this forum is gonna happen. Like, just that's the type of determination we got. So I just appreciate Jackie even more. Like, I appreciate Joanna. Joanna got two phones. She got Amos and she got JJ's sister on the phone. Like, that is it's empowering to me, but it's also disheartening because when his phone call ends, she has to live a life, but it would be great for her to have a spa to go to or have a therapist that we pay for that she can just speak to whenever. And we want to help elevate those services for you guys. So trust me, we hear you and we're gonna do our best to provide those services.
I want to say, right, I'm very proud of you. You know, don't think that you can't do it. It seems very, lonely in the fight because you feel like you're by yourself. And I understand. And let me tell you that you asked the question. It's a very good question. You said, how do we do it? And I'm going to tell you, it's one day at a time, hon. One day at a time. You know what I'm saying? And keep your faith high, because, that's your strength. That's all of our strength. It's our faith, believing. Believing brings creation, all right? And we are strong people. And sometimes when we are weak, we think that, no, sometimes we think that we're weak, but when we think like that, that's when we're more at our strongest point in our lives because we're struggling for survival. We're struggling for our loved ones. You know what I'm saying? And coming to places like this, it's only going to make you stronger. People are going to come out and help you. Let me tell you, right, that it took me 33 years. 33 years for a crime I didn't commit, and they still have me on parole. Can you believe these people? They let me out for 18 months, and then they threw me back in the can. They're heartless, they don't care. And that's what we have to stick together because in the unity is the strength. You hear me? So
Thank you. I hear you. Thank you so, so much. I needed that. I really did. I believe in his innocence. I know he's innocent. I know he's not supposed to be there. So when he called on me to advocate or to help him, I stepped up with no problem, even though I was going through whatever I was going through. But to know that you guys, I'm telling you, you just guys just uplifted me hearing that, especially Pedro. Thank you so much for that because I was at a past where I didn't understand what was going on. Why am I not, why am I feeling like the way, everything is coming down? Why can't I do more for him? Why am I not really out there? And still trying to maintain, like you say, my day to day, my everyday life, that I still have to do what I have to do for me. But I do want to be a part of this. I do want him home. So to know that I have HTP, I'm telling you, I want to say thank you, thank you, thank you guys so much for this because it's really bringing me back and allowing me to express how I'm feeling, but also be a support and keep advocating for him and his freedom. So thank you so guys so much for that.
Peace.
So everything that Fu mentioned about us being able to take care of one another, we're going to do it with professionals, but we're also going to do it with one another because a lot of us have skills, we have resources, and we want to be able to bring all of that inside a space to be able to support each other without having to talk about legal. It'll just be about us. Like, when do we put ourselves first? So thank you, Sharice. Thank you, Latanya, Joanna, everybody that's on this
I
call.
just want to say one more thing. This is for Jeff because he wants me to step up. I don't know how many of you know Asian T, but we just want to keep his name at the forefront, keep him in our thoughts and our purse.
Asian T is the most selfless person that I probably met, right? So finances, anything we needed, he'll cuss me out for saying this. But anytime HTP need any resources, HTP, HTP, Agent T is a part of HTP's identity than I am, right? Because he's in the yard getting people, holding them accountable. He's learning his case. He's a beautiful example of why we do this work, right? And he's the only one still that has an award named after him, the Agent T Award. That's a brother that was in the yard just playing around that changed his life with law because that's what Agent T did. So when we see a brother coming up and doing his thing and staying focused, we awarded him the Agent T Award, and that just means we'll get him a nice meal. We may give him some, stamps if he isn't doing too well. But Agent T is a perfect example of what Harriet Tubman Project is about.
As always, I'm just going to close it out with the guys that we're fighting for. And I dropped a PDF in the chat. Before you leave, please grab that PDF. It's an outline of a motion, exactly how you can write up a motion of your own. So save it and send a copy to your loved one.
I put Luke Nelly's picture in the chat real quick. I was trying to find it.
You did? Okay, I'm going to add her. She's going to be the first lady on our roll of pictures. I'm excited. If you can just send me how many years she's been incarcerated, that'll be helpful. And I'll put her right next to her brother.
Yes, they'll be out
Okay.
soon, but until then, we're gonna do our best to bring awareness around her plight.
Thank you.
Welcome.
Good night, everybody.
Good night.
Nah, good seeing y'all.